This November, you'll probably be asked to vote on an amendment to the Ohio Constitution. Over the next few minutes, I want to walk you through the language of that proposed amendment and explain why it's dangerous and why ultimately you should vote no on November 7th. Number one, the proposed amendment is deceptive and it hides an extreme, almost completely unregulated abortion regime with a bunch of things that sound perfectly innocent. Number two, this proposed amendment is a direct attack on parents' rights to protect their children. Number three, the proposed amendment opens the door to puberty blockers, so-called gender transition or gender-affirming care, and more, all without parental consent or even notification. And fourth, it would authorize abortion through all 9 months of pregnancy. And in every single case, the abortion provider gets to decide whether an abortion is legal. Along the way, as we walk through this amendment, I want you to keep two very simple questions in mind. Who and what? Let's dive into the amendment. The full title is the Right to Reproductive Freedom with Protection for Health and Safety. Who's pushing it? A pair of pro-abortion groups, Ohioans for Reproductive Freedom and Ohio Physicians for Reproductive Rights, with some additional support from Planned Parenthood and the ACLU. And what is the amendment? This is a proposed constitutional amendment that would radically change our state's abortion laws. In fact, it would wipe most of those laws off the books completely. The wording of this amendment is as vague and unconstrained as possible, and that was entirely on purpose. So let's walk through this proposed amendment and see how it works. The amendment has 4 sections. The first section, Section A, states that every individual has a right to make and carry out one's own reproductive decisions, including but not limited to decisions on contraception, fertility treatment, continuing one's own pregnancy, miscarriage care, and abortion. So let's ask our questions. First, who has this right? The proposed amendment says every individual. The United States Supreme Court has said, and Planned Parenthood clearly believes, that children and teens can make reproductive decisions. And so every individual is not limited to adults. Second, what does the right include? The amendment gives a list, but reproductive decisions includes, but is not limited to that list. And that phrase is broad enough to include almost anything involving the reproductive organs. In fact, in its most recent annual report, Planned Parenthood reported a massive uptick in transgender services, including cross-gender hormone injections and puberty blockers. You'll notice that the amendment never uses the words woman or mother. The language of the amendment itself assumes that a person can change her gender or that men can become pregnant. It should come as no surprise that this amendment would make that belief the law of Ohio. What's the point of that list of rights in the first place? It's to smuggle abortion in with things you already have the right to do and things that sound fine on their own. You have always had the right to carry your baby to term. You have always had the right to miscarriage care. The only thing that this amendment would add is abortion. The pro-abortionists want you to think that you have to say yes to abortion in order to say yes to life. Nothing could be further from the truth. Let's move down to Section B. The first part of Section B says that the state shall not directly or indirectly burden, penalize, prohibit, interfere with, or discriminate against either an individual's voluntary exercise of this right or against a person or entity that assists a person in exercising that right, unless the state demonstrates that it's using the least restrictive means to advance the individual's health in accordance with widely accepted evidence-based standards of care. Your eyes may have glazed over there towards the end because this section is full of legalese, but I'm here to help you cut through it. So let's go back to our questions. Who does Section B apply to? Well, it forbids burdening the woman who seeks an abortion, but it also forbids any burdens on a person or entity that might help her. And who could that be? The most obvious person or entity would be the person actually performing the abortion, which, by the way, doesn't have to be a doctor. It also includes the abortion clinic, or really any facility where the abortion is performed. It includes a person who drives a woman to get an abortion, an Uber driver, the high school basketball coach who impregnates one of his players and then drives her to the abortion clinic, then gets to enjoy the protections of this amendment. You should also be asking, well, what counts as a burden? We're not writing on a blank slate here. In the 50 years since Roe versus Wade, courts have described several things as burdens on abortion. For example, parental consent and parental notification laws. So, under this proposed amendment, the state cannot require an abortionist to tell you that your 13-year-old daughter is getting an abortion. The state cannot require that the nurse at your son's elementary school get your permission before giving your 5th grader puberty blockers. Waiting periods are also considered a burden on abortion. Nearly 2/3 of women report feeling pressured to abort. Waiting periods require a woman to take a short pause, which can be as little as 24 to 48 hours between asking for the abortion and actually getting the procedure. These laws are meant to be safety valves. They give a woman time to think and to consider her options instead of being pushed into a crisis-driven decision. This amendment would wipe those laws off the books, giving abusers once again a free hand to pressure women to abort. Informed consent laws are considered a burden on abortion. Informed consent laws are common to every medical procedure, and it simply requires a doctor to give you factual information about the risks and possible complications of whatever medical procedure you're getting. But under this amendment, those sorts of laws won't apply to abortion anymore. And what about that last bit about least restrictive means to advance the mother's health in accordance with widely accepted evidence-based standards of care? It either sounds really positive, widely accepted and evidence-based are great things, but it's actually meant to kill most safety regulations for abortion clinics. This is one of the few ways that states were actually able to push back on abortion when we lived under Roe versus Wade. These are things like laws requiring a clinic to meet the same safety standards as an outpatient surgery center, to maintain sterile equipment, to build doors and hallways wide enough so that if there's an emergency, you can actually push a gurney all the way through the building. There's a second part to Section B, and it's perhaps the most deceptive one yet. It says that abortion may be prohibited after fetal viability, but in no case may an abortion be prohibited if, in the professional judgment of the pregnant patient's treating physician, that abortion is necessary to protect the pregnant patient's life or health. At first, this section sounds like it allows the states to restrict abortion after viability. It's sort of a return to the world under Planned Parenthood versus Casey. And that is exactly the story that the pro-abortionists are going to tell you. But that story is a lie. And you can see this lie if you go back to asking who and what. The state cannot restrict any abortion, not even after viability, if the pregnant patient's treating physician says that the abortion is necessary to protect the mother's life or health. So who is the treating physician? It's the abortion provider. The state can never forbid an abortion if the abortionist himself says it's necessary to protect the mother's life or health. Well, what does the phrase life or health mean? If you're thinking that health means some kind of medical emergency, that's exactly what the pro-abortionists want you to think. But that's not the full story. You see, when the Supreme Court decided Roe versus Wade, it actually defined health. And it said that health includes emotional, mental, financial, and familial factors that bear on health. So if the abortionist says that an abortion is necessary to keep the mother from being sad, or if having a child would be too expensive, then he gets to perform the abortion. And pro-abortion lawyers have argued in Ohio in the last year that abortion is actually safer than carrying a baby to term. So you can be sure that an abortion provider is going to certify in every single pregnancy that the pregnancy itself is a threat to the mother's health. What all this means is that the abortion provider gets to decide every single time whether to perform the abortion, from conception all the way through the baby's due date. You should also ask, what does fetal viability even mean? And for that, we turn to the definitions in Section C. In Section C, viability is defined as the point in a pregnancy when, again, in the professional judgment of the pregnant patient's treating physician, the fetus has a significant likelihood of survival outside the uterus with reasonable measures. This is determined on a case-by-case basis. Let's remember our questions. Who decides when a baby is viable? The pregnant patient's treating physician. And who is that? The abortion provider. And what does viability mean? It means that the baby has a significant likelihood of survival. That is, significantly more likely than not, better than 50%. As a practical matter, that means that viability is going to move to somewhere between 25 and 27 weeks, close to the end of the second trimester. It's important to contrast this with viability as it's currently defined in Ohio law. Right now in Ohio, viability is defined as the point at which, in the determination of a physician who is aware of all the facts and circumstances of the pregnancy, there is a realistic possibility of maintaining and nourishing life outside the womb. A fighter's chance is all you need. And that puts the viability line at closer to 22 or 23 weeks. So what this proposed amendment would do is move the line of viability of the babies that Ohio is allowed to protect from 22 weeks to 27. And it allows the abortion provider to make the decision every single time. Section D is last and least. It simply states that the amendment is self-executing. That means that it will take immediate effect, and it doesn't require any legislation from the General Assembly to give it force. It means that once the amendment passes and goes into effect, your parental rights are immediately gone. Abortionists immediately get to decide in every single case whether to perform the abortion. This amendment would radically change and, in fact, wipe out most abortion laws in the state of Ohio. It's a permanent change to our permanent Constitution. The women of Ohio deserve better. The parents of Ohio deserve better. Vote no on November 7th.